So good afternoon, everybody. Thank you so much for coming over to my session. I do understand it is a very, very dry topic, and I think it's not one of those things that you feel like, hooray, personalization, fantastic, I love data protection. No, not many people take that way. Anyways, I am Sachiko Scheuing, and I am a privacy professional in the field of marketing. I actually work as a European privacy officer for this company called Axiom that does marketing services and consumer data. What I would like to do today is talk about privacy paradox, what it is all about, and then touch on two legal concepts that are very important in making sure that your data use is compliant. That's the legal ground and the risk-based approach. And at the very end, I would like to touch on AI governance and laws around the world that are starting to pop up to regulate AI use. So here we start. The personalization paradox. I think you know about this. Well, every marketeer does. What it is that consumers expect their message to be personalized, to be relevant. And actually, this company called McKinsey, which most probably you know, has done a survey, and it turned out that 3/4 of the surveyed expected communication to be relevant. What's even worse, if you are communicating in an irrelevant way, a little bit more than 3/4, so 76% to be precise, would get really angry. They get really irritated if the message is not personalized. They feel frustrated. Also, there's this survey that the GDMA, Global Data and Marketing Association, have carried out. This is the result for the UK. But what they found out was exactly 3/4 of the surveyed either weren't bothered about how data is being used in a commercial sense, or they were data pragmatists thinking, well, if you get something out of it, why not? But here starts the paradox. What are we going to do with the 1/4, 1 in 4 persons who are really adamant, who would never, ever in their entire lives, ever allow data to be used for some other purposes or in a commercial context when not necessary? The thing is, the law of data protection is all about making sure that people have control over their data. So even though if it's just a quarter or a small minority, you still do have to ensure that these people have the right to control the data. So this is the personalization paradox. Let's make it a little bit worse. The laws are changing all the time. Now, this is the so-called blue curtain shared to me by this really experienced person from the European Parliament's assistance. He actually mapped out around 70 laws in Europe that governs the area of digital data use. These 70s are actually not just there, but they're also evolving, they're changing. You thought GDPR was all right. Well, GDPR, the moment the UK has Brexited, the government said, well, we can actually use the learning from the GDPR and make GDPR better for us, that work for us and our economy. So they came up with this data protection and digital information bill. Bills are like draft laws that have not been accepted yet. But what happened? No longer. This initiative, of course, had to be withdrawn because of the dissolution of the parliament. And just, I don't know, Have any of you heard the King's speech? No? In July, there was this wonderful, wonderful King's speech. And there it was announced that the new government is going to work on digital information and smart data bill. Now, this bill is actually going to be all-encompassing. So all the work that the government has been carrying out to upgrade the GDPR would inevitably flow into this new initiative. And also what they are going to do is they're going to cover other areas like AI as well. So we do need to watch the space. See, fantastic. Personalization, but there's a lot of paradox that we have to overcome. So now very quickly about data. Companies usually have their own first-party data, i.e. their own data, to actually enable the personalization or shaping the communication so that it will be relevant for everybody. On top of that, you can also buy data from outside the company, like social demographics. I call it cartographic data because there are a lot of these data that are available, not in personal level, but like street sections and micro cell level, like neighborhood level, which are really quite good. Like, you know, you also get information about like hobbies and interest in, traveling to destinations far abroad and things like that. So you can purchase in these third-party data. And also, of course, I think some of you have experienced that, you know, my company, your company, we actually are in totally different fields, but we have the same audience. Why don't we have a joint promotion? Here you go. Second-party data can be used. Those data that are being shared can actually be called second-party data. And also for marketing campaigns, for communication, to deliver the message, for measuring responses. Were your campaigns successful? So that you can go to your finance department and ask them, hey, next month I also want to do another campaign. Can I have some more money? It's of course much better when you can say, well, my campaign was so successful. What about investing in my new campaign? You know, it is so much more convincing. So for measuring, you also need data. And third of all, campaign planning. Which audience to select? There are many, many audiences that you can select from many, many platforms, but which ones are actually relevant for us? All these things require data protection considerations. Let's get into one of the basics that I personally feel very important. Data protection, not only the GDPR, but also other laws all over the world use this principle, and that is, what is your legal ground? Having a legal ground. So legal ground is something like, you know, you sort of like defend yourself. You say, I am allowed to use the data because, and then you see there, because it's a legal obligation. I have to use the data. Or because if I don't use this data, somebody would die, you know, vital interest. I can use this data because there is a public interest, legitimate interest, because I have a consent, or because there's a contract. If you are using the data, your excuse, if you want so, have to be one of these 6 legal grounds. But of course, in marketing context, not all 6 legal grounds are relevant. By the way, for those of you who are interested, this is UK GDPR, Article 6, number 1. There are all these different, oh, sorry, that was 2 legalese. Anyways, but obviously, for marketing, it's very unlikely that there's a legal obligation to show you a personalized advertisement. Therefore, legal obligation is not going to be relevant. It is also very unlikely that you are carrying out marketing activities because you want to save somebody. Somebody's life must has to be saved or something like that. It really usually comes down to the 3 legal grounds: legitimate interest, consent, and contract. Contract doesn't actually mean that because I have a contract I can use your data, but specifically, I have a contract with your company so that your company can show me advertising. In only that context you can use contract. So for the vast majority of ourselves, contract is actually not going to work. I actually also wanted to point out something, that companies like Meta, they even sort of, Meta is actually in the business of customizing information. So you can also say customizing, so I can see information about what my mother is doing, what my friends are doing, and so on. But I also get customized commercial information. So they thought perhaps they can rely on that. Austrian court actually, said that, yes, I confirm you can use it. But still, with all these other reasons, other legal and jurisdictional developments, even they are not able to use contract as their legal ground. So I think it's safe to say, let's forget about that legal ground and concentrate on the other 2. We have consent, and I think a lot of you may think consent is like the holy grail. If you have consent, you are privacy compliant, you are very, data protecting. I'd really like to challenge that. First of all, it's very inflexible, so legally speaking. There is this clause, Article 6.4 in the GDPR, which was written as the so-called big data clause, so that you can actually recycle data. You can flexibly use data that you have collected. With all other, I wouldn't say all other, with, let's see, legitimate interest, the other legal ground, you can do that. But when you have collected that data using consent, for like communicating those people, sending advertising, you can't use the same data for analytics, right? It is so inconvenient. So unless you really need to use consent, I'm actually not really sure if this is a good legal ground. The other thing is, like, you have additional obligations like data portability. But most worryingly, and this is my my biggest concern, have any of you heard of consent fatigue? Do you know what consent fatigue is? Yeah, I see some heads nodding. Consent fatigues refer to this syndrome where, because you are confronted with the OK button throughout the day, 24/7, it's always like consent. You open a website, consent. You download an app, it's okay, okay, okay. The thing is, firstly, you feel that, well, why do I have to bother? I have to click OK anyways. So there's this sense of resignation. The second, more problematic reason why you have to be worried about consent and the consent fatigue is because there is this deep psychological impact on you, right? If your mom said, you stay at home, no matter what you do, you have to stay at home. What, you want to meet up with your friend? No, you have to stay at home. What would you do after being hammered out for a day in and day out? The little boy or a little girl stays home, right? Successful education. But imagine if you are confronted several times a day to have to obey by clicking OK over and over again. What you are doing is you are disempowering the population. You are actually taking away the feeling that I have more control over my life. Now, it's very interesting because data protection, these laws were born in the 70s exactly to avoid that type of behavior. The legislators wanted people to be empowered to have more control over their data. So I think this is really, really problematic. Besides, consent is something like, you said okay, so anything that happens, it's your fault, consumer. Your fault, user, you clicked OK. The other legal ground, the third legal ground, my favorite legal ground for marketing purposes is the legitimate interest. Because unlike consent, when you actually use legitimate interest, you have to always be responsible in a fashion that you weigh up your interests, how you want to use your data. I want to measure whether my campaign has been successful, or I want to study what type of hobbies, what type of person my customers are, right? That is my interest because I want to sell more of my products and services. You need to weigh that up against the rights and interests of the consumer or your customer, and then say, well, does that make sense? Is my interest greater than that person, my customer's interest? When their answer is yes, then you can actually use legitimate interest. Legitimate as in like not illegitimate, right? Illegitimate is out of question anyways. So, and it is very flexible. It can make use of this big data clause, so Article 6.4 of the GDPR, and it's even better. The GDPR actually recommends you, right? By clearly stating in their recital. Recital is like, up front they have like all sorts of description and an explanation about small bits and bobs in the law of the GDPR. And there it says, recital 47, to use data for marketing purposes, it can be based on legitimate interest. So consent is not the holy grail or whatever you want to call it. Legitimate interest may be more appropriate. And by the way, most importantly, when companies use legitimate interest as a legal ground, you are in charge, you are responsible. So if something goes wrong, you need to take care of it. You don't push that over to the user. So I also feel that that is fair. Interestingly, there are situations in which you cannot use legitimate interest as a legal ground, which is usually the case when you actually need to send emails for email marketing, or, very important, cookies, fingerprinting, MAIDs, whatever. When you actually need to read information on the device of the person or store information on the device of the user, then you do need a consent. So in that situation, yes, I can say all sorts of things like, oh, legitimate interest is wonderful, but still, if it is in these circumstances, you're not allowed to. Back to this data use. So of course, communicating ad delivery, you can use consent or legitimate interest. Measurement, I think you can also both use consent and legitimate interest in that you can ask people, can I use your data to measure the performance of my campaign? And lastly, campaign planning, I think you most likely would like to use legitimate interest as a legal ground in carrying those things out. That was heavy, but it was still just the first bit of legalese. Let me get into the second bit. Understanding the risk-based approach. As I said, data protection is not the only rights and freedoms that our legal systems protect, right? There are other rights and freedoms. For instance, the right to conduct a business, the freedom to conduct a business, and all these other things. So what you actually have is a law called GDPR that is actually really quite balanced. So what it is saying is that, this legitimate interest, for instance, it's not saying you can do this, you can't do that. No, they're saying balance it up. What is your interest? What do you want to do? What would the consumer or the user feel about you doing that? And when it's okay, then you can use. So it is about balancing. Most importantly, also, in that recital, so, at the beginning of the law, it also says that data protection law has to be balanced against other fundamental rights. Now, let me translate that into practical terms. How many of you are working in a company where there's a legal department? Right, quite a few of you, right? So what happens if you ask for a permission to the legal department and they say no? What do? You don't do it, right? Because you are told no. Data protection does not work that way. If your legal department or your data protection officer says, no, that's no good, then you need to get into a dialogue. How can I make it okay? Because it is about balancing. It is not black and white. I mean, in most cases, you know, there are certain cases where it's so obvious that you really can't actually argue about it. What GDPR has is this approach called the risk-based approach. In other words, the less the risk, the more okay it becomes for you to use the data. So let me talk about a method of actually decreasing the risks. Some of the safeguards. That's why, you know, get your law department, get your legal department to you, and then say, hey, you know what? Can we then contractually agree with our service providers so that it is really tight. We don't have these contractual risks, or you know, you separate the access control. You control access, so not everybody in your company can access this data, but only those people who truly need them. Separating data. You know, for instance, there are CDPs where you can actually have like a structural separation of different data, but when you need it, you can actually have queries to combine the data and use it for that purpose. Put those things in place. Outside of your organization, you can also have trusted third-party and data clean rooms. Now, these are actually, these mechanisms allow, among other things, for you to share data without actually giving up the identity of the data to another company. So for instance, when you're actually doing a joint promotion or you're actually doing audience selection, you don't want to necessarily tell, I don't know, let's say Google that you have this person as a customer, because if, say, you are a BMW and, you know, John Smith is a customer at BMW, by actually, you know, giving that data to Google, Google now knows that John Smith is a BMW owner. You know, this sort of a thing you don't want. So a lot of companies actually use they call it Chinese wall in between, so that data is kept separated using a clean room. Encryption, pseudonymizations, these are, of course, the standard thing. And also, my favorite is actually anonymization. If you can anonymize data, for instance, by aggregating the data, so instead of talking about one person, aggregate, like make an average, calculate an average of 2, 3, 4, 5 persons, right? Then that's no longer attributable to a natural person. Or you can actually use differential privacy. What is that? That is actually, you know, throwing in, say, a small percentage, let's say 3% of fake data in your real data, through which you don't really know what you are seeing is that if that is correct or not correct. And so on. There are other ways, like synthetic data, homomorphic encryption, and so on. Another thing is you can also always use non-personal data, like data that does not have personal origins, such as geo-level aggregated data and so on, which is going to be so much more important the moment we have this new law in the UK governing also AI, data for AI training and so on. So last but not least about AI, there are several binding principles in AI use, which is quite nice because it, you know, nicely squared it. You have privacy and data governance as an integral part of AI governance. And this is actually coming from the EU AI Act. And what I'm seeing is EU AI Act has actually taken, for instance, definitions from international organizations such as the OECD. And that definition is, again, also present in the executive order, which Joe Biden has signed, like a year ago or something like that. They are all very similar. And what they're trying to do is they're trying to actually make the interoperability of the law throughout the world possible so that you can actually be more free in sharing knowledge from one country to another. And I think this is coming to the UK too. So transparency, diversity, non-discrimination, societal and environmental well-being, these will come. And also, interestingly, the AI Act, the EU AI Act, takes a risk-based approach. What does that mean? The more you lessen the level of risk, the less risk you have, the more freer you are in using whatever AI application. And luckily for marketing, most of the applications fall under low and no risk, for which there is actually not so, pretty much you just need to know that you are doing it, but not so much additional obligation. There are different marketing AIs that are available, and I today want to touch on the generative AI example. So, you know, creating images for marketing purposes is usually really tedious. You need to actually, you know, bring the car there, book a location, get a cameraman, and so on. But with this AI tool, you can create it right away. What you can actually do with some other off-the-shelf segmentation, you can actually specify that to tailor-make the image. For instance, in this case, Axiom's Personic Cluster 7, which is a segment with young, you know, career-oriented women. You can also use that for, say, tailor that picture with AI to suit cluster 74. And this new cluster is all about suburban people, mixed gender balance, a little bit older. And you see, it creates several variations of the picture, and almost instantaneously, but it, you know, it is not to say that it's free of problem. I mean, you know, it's quite scary, some of the sceneries that they make. So you still need human intervention at this stage. But at the end of the day, it opens the possibility to mass personalize, which is amazing. And here I just want to show you as the very last thing, there are some AI applications that, however, can be considered sensitive. Emotion recognition is one thing. The supermarket said, well, you know, if people want to come in, they need to smile. They need to smile. Oh, you are not smiling enough. Smile, smile, then the door will open. Smile. You see? In this way, because there's this philosophy behind it. There's this research by these Greek academics that says when people are smiling and are in a good mood, they spend more. So very, very clever. But of course, this would fall under middle risk, a slightly elevated risk of data protection. So, like, you know, interacting with people, recognizing emotion, and so on, they can fall under higher risk, which means you need to have additional obligations. Now, I'm saying this is just for the EU, and if you are providing services to the EU, this would apply. But as it stands, I think for us, the best thing is to watch the space for the UK. And of course, why am I here? It's because I wrote a book about this and so much more. If you're interested, I am going to be at the Kogan page stand A62, that's somewhere over there. Please massively come over to the stand, and I'm actually going to be doing a book signing for the next half an hour. But thank you so much for your attendance, and wishing you a wonderful day. Thank you.